Good afternoon. My name is Arran Hunt. I'm a partner here at Stace Hammond, and it's the 4th of June. And this morning we had MP Andrew Little releasing details on changes to the Property Law Act. So I thought I'd do a quick video on this. We're waiting for the final details to be released, but for now, we're going to cover what we do know. Now, apportionment of rent is one of those big topics that we've been discussing for the last few months, at least commercial lawyers have. For those of you who don't really speak that legalese, it's some horrible words we use sometimes. Apportionment of rent basically means the discount of rent, or who pays the rent during a situation such as this. Now, some firms have taken the approach that it's 50% is fair, and I don't like the word fair when it comes to law. Law is just. It isn't fair. That's it's a very emotive sort of thing. We've taken a approach of contractual interpretation, and we had a lot of success from that, getting our clients some rather large discounts and doing some good work with landlords and with clients to sort of build a commercial reality sort of going forward as to how things are going to work. We've done a previous article on this. We'll link to that in the notes below, and also in our written article that accompanies this video. Now, Andrew Little has released a few details. The wording he's used is that it will insert a clause in commercial leases requiring a fair reduction in rent where a business has suffered a loss of revenue because of COVID-19. Now, there's a few issues we have with that. We're going to sort of cover those. First thing to notice is that businesses have already come to an arrangement with their landlord will not qualify, even if the new implied clause would provide a benefit. But we think that's a dangerous thing to do, because it means that those companies who have been proactive, who are looking out for to minimise their costs so they can keep paying staff, they can make sure that the money's there to pay creditors, and basically run the business as they should, they could miss out here because they have been proactive. We think that is a dangerous thing to encourage companies to be, that the companies should just sit back and wait for the government to act, we think is a bad way to do things. Second thing we're going to cover is the loss of revenue. The apportionment shouldn't be based on a loss of revenue. Because say a business that had a lease but had little turnover, maybe in a startup, it was building things up, would have the same cost outgoing as an established business. If the established business has a greater ability probably to survive during the period, they might have a cash there, they might have relationships with creditors, relationships with suppliers and with customers, easier to borrow money with an established business, the financial history, where a startup won't have that. But the startup won't also have the show a loss of revenue because they haven't had much revenue in the past. So we don't see why a startup should have to get less benefit than an established business just because they're a startup. Same regard goes to a company who may have actually shut their doors, sadly. They may have an empty site, they're still paying rent on it, but because they have no revenue and the site's not being used, under this what's being proposed, they would still pay full rent despite the property being unusable, whether they want to use it or not. We don't think the revenue that would be being gained should be a factor in that. It also requires the tenant to provide the landlord with financial records. Well, we're assuming that we know no other way that they'll be able to show that there has been a loss in revenue. And the tenants may not want the landlord to know how much they're actually making, especially when it comes around to sort of a renewal period, or perhaps there was a lower rent earlier on, and the landlord wants to now bring it up because, hey, you're making lots of money. Third one, of course, is the fact that, arbitration is just, it's a bad idea. This will seek to sort of, the government will pay some of the arbitration costs, but arbitration is expensive. It is the last step we would encourage clients to go. Second, of course, after going to court, would generally go to clients, look, you want to, the requirement that you will negotiate in good faith with the other sides, then go to mediation. We can sort of try and mediate a resolution. Arbitration, for those who don't know, and I didn't know until I was a lawyer, arbitration is basically the same as a court procedure without the court. So you're still getting an arbitrator who will often be we dealt with them as a former High Court judge or a QC or someone who's established and knows what they're doing. And you still have all those steps, all that paperwork, all those steps in between, the delays and the cost and the time. And $6,000 for the arbitration costs being 3/4 of the cost, that is very cheap arbitration. In reality, you will have a tenant who is possibly paying $20,000, $30,000 a year in rent. They could be the arbitration costs. They could basically be spending 3 or 4 times to what they would gain to actually get for a discount. I might want to get $5,000 back, spend $20,000 to get it, and basically they're losing money. it is the worst procedure, worst way to take it. It's the worst path to follow. We can't see the government's reasoning on that. It makes this whole thing kind of useless and pointless unless you are a larger company. So that's just a quick overview of what is being done. We will do a larger in-depth review. We've got a link to an article, of course, to our previous article below. Also a link to one of the news coverages to cover this and a bit more information. We think we've covered all the main details. Until then, we will speak to you next time, and kia haha New Zealand next week, level 1, hopefully. All the best.